Karuna is a face and name many of you will be familiar with if you do consume news content and discussions. We'll start off. There are a few things Karuna had spoken about that we'll discuss, but let's start off with a book that is just been released. It's called Arbitration in India, and it has as editors Dushyant Dave, Martin Hunter, Fali Nariman, and Marique Paulson. Did I pronounce that correctly, Karuna? Marique Paulson, is that how I pronounce it?
It's Marika Paulson, and she's actually my editor, so I wrote it.
And Karuna has written her chapter on this is arbitrating for the environment. Now, before we move on forward, Karuna, tell us a little about what that means. What is this book about, and what is arbitrating for the environment?
So, look, the thing about environmental litigation in India, right? The reason that water is so polluted, that we're choking on our air, and that our forests are getting denuded so fast, it's not because the law is bad. The law is actually absolutely excellent. After the Bhopal gas disaster in 1984, there was a slew of legal changes. There was the Environmental Protection Act, there was the Air Act, the Water Act, there was, amendments, and there was also the oleum gas leak case. Now, what is all this law actually say? It says, for instance, that one has an obligation to exercise the precautionary rules. So you have to make sure that you're using the best technology. You have to make sure that you're complying with environmental laws before you destroy anything, right? Also, there's the polluter pays principle, right? Which is that if you pollute, then there is strict liability and absolute liability, which means that if the company pollutes and it's a hazardous substance, then they just have to pay. You don't have to prove causation and damage and harm and all that. You have polluted, you pay. With all these wonderful laws, what is going wrong? Because we see around us the travesty, right? And the kids are suffering from it. We are suffering from it. The problem is the process. Now, the process is that these norms are primarily enforced by the state and through litigation. Right? Litigation is slow, and the state is frequently, not active as it should be to prevent these environmental norms from being violated. I was asked to write about the issue in arbitration. There's an idea that was sort of knocking around in my head for a while that I decided to pursue. Essentially, when companies contract with each other, there is almost always now an arbitration clause when it's a big enough company, right? There's an arbitration clause. Now, if that arbitration clause is the classic arbitration clause, which says that any issues arising from this contract, as opposed to only pertaining to the contract, but any issues arising from the contract, it opens up the ability of one company to sue another for any environmental damage caused broadly in connection with the contract, right? Now let us remember that the state, whether it's a state government or whether it's a national government, whether it's central government, is one of the largest contractors, obviously, right, in the country. And even if the state itself used these arbitration clauses for a swift, certain, final order, then there is a way in which, and I won't go into the case law because it's very legal, very detailed, but the judgments that we have so far make it possible to sue another company for environmental damage and get sort of compensation for remediation of the land and for health damage.
Right.
This is important not just because it's swift, but also because it opens it up, the protection of the environment, to a large number of companies that increasingly want to engage in sustainable development.
So, okay, now, before we move on to something that I'm very interested in, which is what is referred to some by judicial activism or judicial intervention in
Yeah.
policy matters. But before that, coming to this, you said arbitration between companies, but what about when
Yeah.
a regular person is impacted because of environmental damage, like happened in that village in Kerala, I think, with the coke plant, right, a few years ago in the late night 2000s.
The Plachimada.
Correct, Prachimada. And then I was listening to a podcast yesterday in the US where I think now for the eighth year in the last 12, California, they're saying it's a drought hit year, and the news anchor was saying that it's all because of big ag, what they call big agriculture. It's not just independent small farmers; they're just sucking up the water because of almond farming. Now, almonds should not be grown in California, but because they don't want to piss off the farming lobby. Now, when that kind of damage happens, it's not between companies; it's impacting me as a regular person. Are there enough legal provisions in place for me to go to court against, like, for example, in Delhi, for the longest time, that coal plant that was running, every time the government would say we're shutting it down, but it only shut down very recently when things in Delhi got out of hand. Are there enough laws in place for us to challenge it? Because there is a campaign like the Right to Breathe, which a lot of people in Gurgaon are actually a part of. And every year we see the kind of the kind of pollution that happens. What about that, which is not between companies?
Yeah. So look, Abhinandan, as an individual, it's always open to you to go to court, right? To go to court directly and to go in a writ petition and say that, look, the government is not following the law. I personally have a right to life. I personally have the right to good health, and I have the right to the clean environment. However, even in the avenue that I'm proposing, if the damage is happening in a legal landscape where there is an arbitration clause, you could also go in a writ petition and say that if the state is involved and there's an arbitration clause there, that the state must pursue arbitration, right? But that's the best remedy. That's the remedy that I'm going to get quite fast. Otherwise, it's going to go up through the courts. It's going to take years, and who knows what will happen, right?
Right.
Also, I think that there are avenues, there are ways in which, and I'm just speaking of this specific thing because I'm interested in it, because I just wrote about it. At the first instance, I have to say, and I say this even as a lawyer, at the first instance, these issues have to be political, because what we've seen in the last 7 years, most of all, is that we have seen massive violations of law and of the Constitution at the first instance. And we have to remember that the court's bandwidth is much more limited than government's bandwidth. What do I mean by that? By bandwidth, I mean the ability to make decisions fast. But I also mean the constitutional ability to keep government in check. The court's constitutional ability to keep government in check is governed by a number of principles. One, Wensbury unreasonableness was the traditional principle, which is that if they make decisions that no reasonable decision maker could make, so the decisions that were less unreasonable than that, which is a pretty high bar, then would flow under the bridge, right? There's the principle of proportionality now that has come in. Well, by now, I mean the last couple of decades, right? That's come in, which is that the principle has to be that the execution of the government decision has to be well tailored to the goal that it seeks to achieve. Now, in all of this, you can see that there are these very rigorous principles. Now, if the government comes up and says, Twitter ko ban kar do, right? Or that we are not going to tell you that your money, that your crores that came into the PM Cares Fund, how we're going to use it. We're not going to tell you that. Because you know what? It's not amenable to RTI. If they say that electoral bonds, there's all this money flowing in from companies, including foreign-owned companies, into political parties. We are not obliged to tell you which companies those are, because, and therefore, you can't see whether there's a quid pro quo from government or not. And you can't see whether, in fact, a few large corporations are running the government to the detriment of the ecosystem, of the rest of the economic ecosystem, right?
What is the status of this case right now?
That is not being heard.
So it's pending, basically.
It's pending.
I see. Now, when you said that you're not a huge fan of the judicial intervention, like it's a political issue first.
No, I'm a huge fan of judicial intervention.
But
I'm a lawyer.
but it has to be dealt with politically first, and I get that these are
Yeah.
political issues before.
Yeah.
But where are you? Because I know there are many journalists, some who I respect for their views, but on this I don't always agree with them, and I think I'm pretty much on the fence on this, on what they call judicial activism, and I often call judicial intervention. I have a dog in this fight. It is the new IT rules that have come out, which I
Yeah.
think are completely unconstitutional, and they put a burden on news
Yes.
platforms, which I don't think it was envisaged for a democracy to have.
Yeah.
So I'm absolutely for the judiciary intervening, but you think there are dangers, there are limits? I mean, I remember listening to this podcast where that Supreme Court judge in the US who died, I think a couple of years back. I'm terrible with names. You'd probably remember him. He came up with this. He ruled on the Bush Gore case, and he said it's a political thicket that if the court enters, then it's very difficult to entangle ourselves. We should stay away from policy matters. Is it possible today for the courts to do that and leave it to the political class, which clearly doesn't want to either look at the constitution or has even read it? And do you see a danger there? I mean, at some point, could it backfire, just like several laws that the UPA put in place are now backfiring on them? I mean, is it, we are celebrating it today, but you think it could get dangerous tomorrow, even more dangerous than a political party, which can be removed through voting, but judges can't?
Look, I think that you have to be consistent, right? So particularly if you're the courts, if you're in the judiciary. So I am in the COVID cases in the High Court, and there's this very fine balance that the High Court is treading. So what was happening was that the central government wasn't giving the Delhi government enough oxygen, right? It was giving the Madhya Pradesh government a bit more than what they needed.
Mhm.
They weren't giving Delhi enough oxygen. Now, this is pretty serious stuff. And what is at stake when you're in court? When you're in court, there is the right to life that is at stake, right? But
Mhm.
if some of these, the way it's executed are policy decisions, then the policy decisions can be executed in a way in which they are at bottom respecting the right to life, right? So they have to conform to a particular threshold. But Niku, I mean, Abhinandan, the example that you raised, the IT rule, I think it's legally speaking, it's a very easy case. Because look at the IT Act, right? If you look at the IT Act, this is completely ultra vires the Parent Act. So you can't just go off and make rules that are so draconian on media like yours and media like The Wire and media like Scroll or even the New York Times website. When your press council regulation and your TV regulation is much more respectful and hands off. You have an Article 14 problem there, which is equality before the law. That's just one example. The second example is, the second argument rather, is that you have a three-tiered system in terms of regulating content, like directly regulating content, right? And you have the ability of this central government constituted body to actually censor content. Of course, that's a problem. So I think that when we speak of the IT rules, to me, there seem to be some fairly straightforward legal arguments to say that these are unconstitutional and against the not just the ability for you to speak, but the ability for me and the rest of the people in this conversation to hear. We have the right to listen. We have the right. We don't have to listen, but we have the right to listen if we wish.
Mhm.
We have the right to know. There are constitutional bench judgments saying that I and you, the people who are in this conversation, have the right to know. So it's not just you in this fight, it should be all of us. And it's a purely clean, it's a very clean set of constitutional arguments.
Okay, Karuna, you said the specific case on this, I get it, but you still haven't, told me exactly what you think about the danger of the judiciary becoming too interfering. And because I remember in my days as an RTI activist, we always used to whine about that courts say we are not under the RTI. Everybody else should be under the RTI, not us. And even in my living memory,
But that's changed. That's changed.
sure. But what I'm saying
Right?
is, this was a tough battle.
Yeah.
Now,
Yeah.
now in my living memory, I don't know. At least in the Supreme Court, I don't recall any effective impeachment having occurred. And one hears stories. There were some small news items that had come about a decade ago about particular cases. The Helka did a full cover story, and Justice Agarwal. In that context, is the Supreme Court or the courts accountable enough for us to allow them to intervene in policy so much that it goes the way of some other countries where the accountability there is not enough, so therefore they become more powerful than even a really centralized government like the present one is that a danger, you think?
Abhinandan, at the moment, I don't know which courts you're focusing on, but what I'm deeply concerned about is the complete opposite. I'm deeply concerned that this government, the central government in particular, isn't being held accountable enough. I make no bones of, and I say this with the greatest responsibility and in the most technical sense, in saying that the central government, and I'm sure that at this point in the conversation, I'm going to lose a lot of agreement in the crowd, but this government is proto-fascist. The kinds of decisions that are being made and the kind of attack that has happened on the rule of law, whether it is unprecedented interference in the appointment of judges, dehors without the structure, whether it's of the national NJAC, the National Judicial Appointments Commission, or indeed anything else, is in itself a massive problem. So you have people. So okay, the collegium system is imperfect. Of course it is.
Before you
However,
go into that,
when
could you
you
just explain to our viewers the collegium system of selecting judges and what the NJAC proposes to do? So just briefly, so they get an idea of what exactly is the system.
Okay, I know you're very interested in the NJAC, but I also think it's a very, very fine legal subject, and it's not even contemporary, right? Like nobody's. It's sort of the challenge has passed and it failed, etc. The collegium system is just the most senior judges appointing appointing the other judges of the Supreme Court and chief justices, right?
Yeah.
So from chief justices. So the collegium system is something that came about, from the three judges' cases where there was a bit of a back and forth between the governments and the judiciary as to how these judicial appointments would happen. The NJC, which Abhinandan is particularly interested in, and I'm happy to answer questions if all of you are also, was a bill that was proposed. Now, it's the devil is in the details, though, right? So the composition of who would then appoint the judges then becomes the crux of the situation. And I think that the reason that a lot of us were against the NJAC, the way that it was being tabled, is because the government would effectively have a veto, and you don't want that.
But right now, when a judge is selected, is that process transparent? Can anyone get access to the minutes of the meeting that happen when a judge is appointed?
No, not at all. No, not at all. Not at all. So the collegium system is deeply imperfect. But the point I'm making, I think, is a much more contemporary and much more burning point, right? Which is that this imperfect collegium system, and of course we want something that is better. And I'm going to give you examples from the UK and the US. The US people are much more familiar with because it's all televised, so very exciting. And there's this filibuster process, all that happens, right? But I give you examples of both these jurisdictions, both of these countries that are in a way at different places. So the way the collegium system is, in a sense, being bypassed is that you have junior judges now being appointed to the Supreme Court at the instance of the government, right? So they usually, almost always, what happens is that you have to be either a chief justice or an acting chief justice. I mean, we have examples of judges who made decisions, in the Delhi riots, and I was in that court on that day. So a decision that was made calling members of the ruling party to account for instigating violence. And like the same day or the next day, within a few hours, judge gets transferred, you know?
Mm-hmm.
So there is a lot that we have to worry about. Would I be worried if judges were going absolutely in the other direction? Of course, I'd be concerned. And of course, that's not okay.
But we're not there yet.
You know? We're absolutely not there.
We're very far from. Okay. We have one question that's come in. And this is about the IT Act. So we'll just deal with it now rather than push it for later. It says, while I agree with all your assertions regarding the IT Act / Twitter, etc., we are also aware that social media is highly divisive, and with all the fake news it can cause, immense law and order problem. What's your take on it? So today, our law minister, I don't know whether you are reading the news up in the hills, but our law minister.
I saw that.
Yes, so of course it was to do with IPR, which happens to many of us. But yeah, that's the question. Is that a concern? And should IT Act address that? At least, if not news media, at least the large big tech and big social media.
I think that's a good question, and it's an important concern, and I actually agree with. What's happening under cover of dealing with fake news? You have the editor-in-chief of The Wire, the same sort of group of digital media that Abhinandan is a part of, who has been called under some sort of law that prohibits fake news, right? In a criminal case.
Also, it says spreading disharmony is what they said, but yeah, whatever that means, and I don't know how they interpret spreading disharmony, but yeah.
Yeah. Taking today's case, and I chose to be here rather than a TV channel on this particular issue. Today's case is an interesting case, right? Because what the law minister, Ravi Shankar Prasad, did was innocuous, but the notice that Twitter apparently received was under the DMCA, the US law, asking for a takedown, right? Now, in such a situation where you have a social media company that is trans-jurisdictional by its nature, right? And you have court systems that are limited by their borders.
Geography, yeah.
Then you have a sort of weird sort of clash where you have someone who took recourse to the US law, and then which they are much more likely to comply with. Let me be clear here that I'm not saying that there isn't a first world developing country problem with these social media giants. There absolutely is. Then you have this bizarre situation where the law minister suspended for 1 hour for something that is really fairly innocuous. What should the social media company be doing there? I think that the way the social media companies should work is that they should have a notice and take down situation, and then there should be a sort of adherence to terms of service, which also allow independent fact checkers, and that's something that's happening to an extent, to look at the fake news, because the mass reporting is something that isn't working particularly well, right? Because I was telling Abhinandan that I've blocked the entire IT cell, and actually in response, it was interesting. The chief IT cell, Amit Malviya, blocked me back. I think but I was pleased about that. But the fake news problem is difficult. It's something that I grapple with in my capacity on the Global Free Speech Committee at Columbia, and on the high level media freedom panel, England. On the margins, though, it's not difficult, because if someone's saying that, for example, the anti-vaxxer stuff, Twitter is being pretty good about taking, the sort of crazy anti-vaxxer stuff. I'm not saying that all the anti-vaxxers, quite a lot of it is crazy, right? And so I think that kind of fake news, having fact checkers, having the report in regime is quite good. It's not something that we clear solutions on right now, because it's a tough problem. This is your real news, right? Often in these divided, polarized worlds, right, because of social media.
Mm-hmm. Okay, so now coming to the imperfections of judicial appointments, or how courts are reacting, or how the governments are reacting to court orders or transfers. Two of the longest pending things ever since I've been an adult and been following the news has been police reforms and judicial reforms. One keeps hearing about these every few years, but nothing really happens. One hears that there were
Yeah.
2 crore pending cases or 3 crore in India, and if there were no cases from today, to take another 50 years still to deal with all of them. The judicial appointments, at a district court level, what are the solutions that you think which are actually the lower hanging fruit? I mean, big policy changes will always take a while, they'll be challenging. But what are the lowest hanging fruit to make it more easy and accessible for a regular person? Like, I mean, the case that I always give is that, when people say that markets are good, and I'm not against, a certain kind of free market with a regulatory framework that is fair. But, you can't compare markets in America to markets in India, where in America, it's a very famous case, although the numbers are exaggerated, where this woman, she dropped hot coffee on herself and she sued McDonald's for it. And she won a sizable chunk of money. There, like a company like Enron can go down. It was the seventh largest corporation in the world, and Kenneth Lay can be escorted out of his office in handcuffs. Here, even when there is land that is taken unfairly from people by large companies, I can't imagine any regular old lady sitting there taking Mukesh Ambani to the court and winning. So no one, I mean, our case against the Times of India group, I mean, I know we've already spent 16, 18 lakhs, and because we are a subscriber funded initiative, and, we just put out an appeal and people are very generous, they give the money and we can fight the case. Any other small organization will say, okay, we'll take it down, we don't want to mess with Times of India. How does one make the judiciary friendly to people who can't afford the big bucks, and it can win against the largest corporations? Do you see that happening, and what are the ways that can be made to happen?
So everyone knows that we need more judges and we need more courts, right? Everyone knows that the efforts are being made, they're not being made fast enough by our entire system, because I think that's the burning need, right? In addition to that, I think that the smaller disputes, and there are a lot of small disputes clogging up our courts, I think that I'm going to give this idea out for free. It's something that I was thinking of, potentially monetizing, is the ability of the common person to go to arbitration, right? So therefore, to have, smartphone penetration now is huge and increasing in India, right? And if you had an app that allowed people to just come on board and say that, look, I'm looking for an arbitrator in this issue. There's a lot of institutional arbitration that's a lot cheaper now. And, you could also book a room quite easily on the same app. Then you have the sort of easy, swift dispute resolution for your 20,000 or whatever it is you've got, right? Or your small piece of land even. That can only be challenged, and you agree to this, that can only be challenged if there's an egregious violation of the Arbitration Act, right? That if it's just you don't get to go on regular appeal, and so therefore you don't get to clog up the court system. I mean, you'd be amazed at the kinds of cases that come to the Supreme Court. I was waiting in court once for my matter, and Justice B.N. Agarwal at the time, who was, having to decide this issue. But it's like, should the bathroom be slightly 2 feet to the left or 2 feet to the right? I mean, should our Supreme Court be, having to decide this nonsense, right? The second thing I think is that as we expand, as we recruit police officers, we can't just say, "Kad kitna hai, chaudai kitni hai." You have to recruit in a way that represents the population, the diversity of the population. Plus, and that's not enough, because it's widely known that people can be patriarchal regardless of what gender they are, right? For example, or people can be casteist, because there's internalized patriarchy, there's internalized casteism. So how does one deal with that? That when you're interviewing these people, when you're recruiting these people, you make sure and I think this is really, really important, because we see decisions where the rapist is being told to tie Rakhi.
Yeah.
To have Rakhi tied by the rape victim. We get all sorts of crazy decisions, right? So I think you've got to make sure that the person has not just the inclination, but the ability, because there is a technical ability that comes with fostering equality, right?
Mhm.
To further the constitution when you are wielding the power of the state. Because if you don't do that, you end up reinforcing the might is right regime. The jiski lathi uski bhains, the lathi becomes a much bigger lathi, right?
Mhm.
So I think that one of the things that is absolutely central now, that what we have to do is that when we recruit prosecutors or police people or judges, that we have to make sure that they are going to further the constitution and they're not going to trammel the constitution. And in accordance with this, look at promotions and rewards and penalties that look at the decisions you're making and look at your record when you're already in service in this regard. And I think this becomes much more of a burning issue when you have political parties that are being so incredibly divisive. There are numerous studies that show that, including a Yale study and very, very credible studies, that when there's a riot, the BJP benefits, and the Congress, for all its many ills, let's be clear, does not. You know?
Mhm.
So if you're going to bring the constitution home, it's not enough to increase the number of police people, to increase the number of judges. You have got to make sure that justice and the constitution is furthered.
So, speaking of, not clogging up the courts, I know in the Delhi High Court had set up a dispute resolution for families. I think for divorces, it was um, a separate. I think it's for no, not divorces, for family conflicts. I forgot what it was called. It's part of the Delhi High Court initiative. How successful has that been to resolve cases before they actually file in court? I don't know what exactly it's called. You must be knowing. The Delhi High Court had set
I'll
something
tell
up.
you about it. So you're talking about something that I love. It's mediation, right?
Right, need
And it's
correct.
not just amongst families. So it's not just amongst, and I'm a Supreme Court mediator. I
I
went through training, and I also had to do 20 successful cases in the district courts, 20 successful mediations before I could mediate at the Supreme Court. And it's something that is very close to my heart. I love it.
so
Right?
how's the experience
Because
been here in the Delhi High Court? Has it
I think
actually?
it's going very well. I think it's going very well, and there are a lot of people that a lot of disputes are being resolved. I think it's at the district court level, it's possibly easier. And I don't know about the Delhi High Court as much because I don't mediate there. I mediate at the Supreme Court, and I have mediated at the district courts. My experience has been that it's much easier at the district court level, right? Because when people have come, they're all in Delhi. When you're the Supreme Court, there's somebody coming from Tamil Nadu, and or there's say two people coming from different parts of Tamil Nadu, and then there's that one day, and then they have to come back, and they've also been through the legal system for a long, long time. So the incentive to get rid of it, sometimes they feel that I might as well just, stick it out and just finish it off and see what happens.
Mhm.
But in Tees Hazari court, I had a couple of incredibly satisfying cases. There was an auto driver who had been deserted by his wife, and she had run off and leaving him with 5 kids. Okay. And he was not giving her a divorce. So we said that, look, I mean, she doesn't want to live with you, and you've been at this for a while now. Is it worth it? Because you're bleeding money and it's not like you have it. So in these conversations, what we realized is he said, मैं उसको घर पे बिठाऊंगा, रोटी पकवाऊंगा, झाड़ू कटका करवाऊंगा, तब उसको पता चलेगा, right?
Which is a power thing.
Which is a no-win thing, because the lawyer heard this and himself got embarrassed. We sort of separated and then came back. And then by the next instance, I mean, there was an amicable separation and it was over. There was another case where there was a child who the parents had joint custody, and the father was getting married a second time and he was fighting the custody. And the mother said that, look, he's been a great dad. I just don't think that the new wife is particularly interested. But then once we unearthed what was actually going on under the application and the counter application and all the legalese that comes over what's actually going on in the case, at the core of it was the dad who was feeling guilty, who's feeling like, I want to fight for my kid, And and I have this new wife coming, and it's complicated. I don't know what to do, but I don't want to abandon my kid. And once it was sorted, because it was sorted then amicably, right? We had this child sitting in front of us, just crying with just gratitude and appreciation, and just saying that I'm so glad that this isn't happening anymore.
So there are a significant amount of cases that can get resolved at the mediation level.
But you know something, I also I was advising the Maldives government on particular legal issues, and I put mediation front and center in this issue because I think it speaks to what kind of society are we? How do we resolve our disputes? Do we sit at a table and sort it out? Do the hard work, or do we let the lawyers in and make it really complicated and clog up a legal system and a system of appeals and fight in an adversarial way?
And often end up with a no-win.
Very often end up with a no-win.
Okay, you spoke about issues that are related to gender. Newslaundry, I think last month we did a infographic on all the high courts and the Supreme Court, the gender representation of judges. How long before you think we'll have a lady as a Supreme Court Chief Justice, the Chief Justice of India? You think, how far are we from that?
I'm not so interested in a woman Supreme Court Chief Justice. I mean, I am, but it's more symbolic than anything else. I'm interested in a true representation, right, across the board, across the district courts, across the high courts, and across the Supreme Court. And not just of women, because I can foresee a situation where you have women like me, right? You have Savarna, privileged women populating the judiciary. Whereas what we really need is women who are Dalit, trans women. We need women across the board, and we need men across the board. We need different kinds of people, because otherwise merit is not being served.
Right.
What you're doing is that you're looking at people who look like you and act like you.
The uniformism. Right? But where is that problem? Are the lower courts more representative than the High Court and the Supreme Court? Is the problem by the time it comes up to the Supreme Court, the representation becomes less narrower and narrower? And if so, why? Why do people drop out of the race, whether it is on gender, whether it is on community, caste, Savarna? Why does that happen?
I think there are a number of problems. One is that it's much better at the lower court levels, right? There's an exam and people pass it, and I think the problem is a lot of people who make these decisions say the problem is with the feeder system, in the sense that you're not getting enough people who are from diverse backgrounds to a point to the Supreme Court and to the high courts. But I do think that it's also true that there are a lot of competent women lawyers, for instance, right? And that's a big pool to appoint as high court judges, and then ultimately that's what goes up to the Supreme Court, typically. Although somebody like Indu Malhotra got appointed directly, so did Rohinton Nariman. I think that, and there are some Supreme Court judges now, as we speak, doing that, actively reaching out, to people that they feel can do a great job. And not just people who are symbolic, but people who will, and not just people who will try to do the same job that their fellow, upper caste, straight, male, able-bodied judge is doing, and say that, oh, I can do it in the same way, and I'll be better than them, and I can, but to do what, I keep coming back to the Constitution, because it's this incredible Excalibur, to further that, to make that happen, and to bring not just their own experiences, but their imaginative empathy to the table, to make sure that justice isn't business as usual, that justice is what was imagined at the outset of this country.
Right. Just had this one more question, and you work closely with Justice Verma. And this is, we discussed this in a podcast a few months ago, and I had the privilege of interacting with him because he was on the jury of our RTI awards that we used to institute. He was a real gentleman. Now, one always cribs about justices and judges while they're delivering a verdict, rather than keep it strictly to guilty or not guilty. They go into philosophizing, etc., etc., and often they get called out for it. But often they're celebrated for it. Now, I was just wondering. I've seen Justice Verma's famous
Hindutva judgment.
Hindutva judgment
I'm going to follow him for a long time.
represented and misrepresented by people depending on what side of the political ideology they're arguing from. Can you tell us what did he really think of it? Because it had started getting misinterpreted in his lifetime. Did he ever talk about what was the intent of his judgment when he actually delivered it, and how it was being seen later? And did he regret having weighed in on whether Manohar Joshi was guilty or not guilty, weighing in on what Hinduism is? Did he ever share any of that with you?
I don't need to. I mean, I wouldn't disclose a personal conversation, particularly after somebody's gone. But he publicly said that it isn't what it was being cracked up to be. It was being made out to be something where he was saying that the Hindutva is the way of life, and that Hindutva, we are all Hindu, etc. He wasn't saying that. And I think all you have to do is read the judgment in that regard, right?
Mm-hmm.
I think there are two things here. One is that when the Supreme Court, unlike in many other jurisdictions, there are various judgments saying that when the Supreme Court or when high courts make comments, right, that are called obiter, there are two parts to a judgment. One is the ratio decidendi, which is the reasons for the decision in fancy Latin. And there's the obiter, which is the stuff that they're saying otherwise, right? Now, the stuff that they're saying otherwise is actually binding on the subordinate courts, okay? So sometimes there's a sort of endless discursive expedition, and it's that all that little stuff is then cited, right?
Mm-hmm.
The thing is that take the Tarun Tejpal case. I don't know, it's a very controversial decision that people are on various sides on. I read that over more than 500-page judgment, and it is blatantly clear to me that there are massive problems there, right? Now, would I know this if the judge had just come and said that he's not guilty? No, I wouldn't. Right? Would the prosecutrix, or the state rather in this case, have the ability to challenge it in the same way? No, they wouldn't. So I also think it's useful. It's useful in that regard.
Right.
But something, justice is only as good as the structures and the people. And we're still a fairly young country. I think we've gone backwards in some ways, but there's still tremendous hope. And I think that there's a lot that's going well. And that's what we need to strengthen, and that's what we need to leverage.
Okay, one last question. Since you spoke out of a case which we were discussing, how do you cover a case which is in cameras when you call it, right? No one's allowed inside. And because then you just have the final judgment to go by. So the news media world well, the court system well. Is there any good and accurate way to cover a case which is in camera? How does a news professional pursue such a case, and what is legal, what is not legal? People can't talk outside court or what happened inside court, because then one can get an idea of, so this happened, so therefore this is how it is being perceived, this is the kind of questioning that's happening. Is there any way to do it sensibly for a news professional for a case that is in camera?
Live law, bar and bench. Very few cases are actually in camera. What live law and bar and bench do is that they go inside and they live tweet it and they report on it, right? They do it in a responsible way, and you know exactly what happened.
So, but anyone can get in, because we were talking to a few
not
reporters.
In the Supreme Court, not in the Supreme Court, and that was a decision that I thought was hugely against free speech. But I can see why they made it. It is still against Article 19, right? Justice Kapadia made a decision way back when, saying that you have to have a law degree to report in the Supreme Court.
Oh dear.
To get a proper pass, right? So now, actually, with those, we're all arguing online. And so usually the link is just shared and now everyone can have access, which is great. I think there's a huge transparency move there. And that's happening in all our courts also. There's a move towards transparency. There's the Gujarat High Court, etc. There's a move towards broadcasting what actually goes on in court, right? I think, which is great. I think the concern that they had back then, and I also think that this is something that the media needs to address within itself, right? Is that sometimes you'd get reporting that didn't really understand what was going
Yeah,
on.
it was misreported. They misrepresented what was said or
Yeah.
what. Yeah, that's a problem as well.
But now you know exactly what's going on. So sometimes actually when for I mean it's very rare, because usually when there's a case that people are interested in, or there that one's chamber is interested in, you send a associate or someone to watch it, right? So that you know what's going on. But actually, Live Law and Bar and Bench have a pretty robust reporting on what actually goes on. So a lot of lawyers rely on that. So as media professionals, of course, you can rely on that, and as sort of average citizens also. I would highly recommend it. Of course, under the IT rules that you referred to, that Live Law is worried about being shut down and is worried about being, prosecuted and censored and effectively shut down. So they're in the Kerala High Court challenging that.
They've
So
got a
as
few
I
people.
said,
They've
so
got
as
a
I
few
said,
people. Yeah,
this
they've got
fight is our fight.
everyone.
This fight is
Yeah.
everybody's fight.
Yeah.
It's not just
All of
Abhinandan's fight.
Bar and Bench is a part of Digipub, and Live Law got a favorable order of no coercive action by the Kerala High Court.
Yeah.
But thanks so much, Karna. We look forward
Thank
to
you.
having you back in Delhi, and maybe the next time the quorum, the audience can get to speak with you
Thank
live
you.
and enjoy your time in the hills. Thank you, Team Quorum. Thank you, Vivek.
We, being an independent platform, depend on our readers, viewers, and listeners. Support independent media by subscribing to Newslaundry. Go to newslaundry.com, click on the subscribe button at the top, and pay to keep news free.